Hello, everyone, and welcome. Sufit here. I am here today with Charles B. Ticker, estate mediator and litigator, and we're here to discuss an interesting question around mediation. Charles, should mediations have deadlines? Should there be a specific time when all parties are going to walk out the door? You know, we're going to do this from 10 to 4 or from, 8 to 3 or something like that? Should there be a hard deadline, or should the parties stay until 3 o'clock in the morning to knock it out, or should they know that they can come back another day? What do you say about this topic?
Well, typically and traditionally, mediations are scheduled, let's say, for a 7-hour full day, with the understanding that the parties, if they're making progress or they feel they're making progress, will go on into the evening hours and sometimes the early morning hours to try and hammer out a deal, or maybe continue on another day. So even though a mediation is scheduled, it's a little different from court, because the court ends at 4:30 and it's adjourned till tomorrow morning at 10 o'clock sort of thing. Mediations are typically a little more fluid. However,
is that a good thing or a bad thing? Does that promote settlement or does that impede settlement?
It's an interesting question because what typically happens is the serious negotiations will start later in the day, and so you have this momentum building because people are looking at their clock and they start building the momentum at, say, 3 o'clock, and then they'll go on and maybe hopefully reach a deal, and then they have to draft the minutes. And is it a good thing? Well, if you go on too late, I think parties get tired and they may have more buyer's remorse the next day if they do settle, or sometimes they might just be stop talking because they're exhausted. So is there an advantage to saying that, we're going to have a hard stop at 5 o'clock? It's a good question. And I was recently approached by a counsel on a mediation saying, I have a hard stop. And the counsel said, I have a hard stop at 5. And I don't care what happens or where we're at, I have a hard stop at 5. And
now, would it make sense in that case maybe to start earlier?
Well, I thought it would be, because I know how these mediations go. They always take longer than anticipated. But when I suggested that, the answer I got was no. It's 10 to 5. Hard stop at 5. Hard start at 10. Okay.
Now, is that person's position, an indication that maybe the person is not interested in settlement, or is it possible that in that person's experience, having that limited period of time actually might facilitate a settlement? What do you think about that?
Well, I guess it could be either. They're not really interested in settling, or maybe they feel that, hey, we need more structure, and everyone knows that there's a timeline, and let's cut to the chase and make a deal. So it could go both ways. I think there is an advantage to saying, look, we don't have to go all night on this, that we can deal with these issues intelligently and reach a settlement if everybody works hard and pushes hard. And instead of waiting until the last minute of the day, let's start focusing on settling a little earlier. My personal bias is I don't like hard stops, because in these kinds of cases, particularly sibling estate fights I'm talking about, there's so much emotion that's coming in the door that I think you got to spend a little time or more time on getting, family background, building trust. And if you put pressure on people to come up with numbers too soon in the day, they're just going to close up and you're not going to settle. That's my personal bias.
And I guess it depends also what you're spending that day discussing. I mean, would that depend on how prepared counsel, are coming in?
Definitely. And in a case like this, where you have a hard stop to end the negotiation, then it's imperative that counsel and the clients are fully prepared for that mediation. And what do I mean by that? We spend a lot of time at these estate mediations, quite often fighting about the size of the estate in dispute or the size of the pie that is available to be divvied up. And, people don't have up-to-date bank statements, or they don't have proper accounting of disbursements or invoices that they've paid or whatever. All this could be done in advance, so everybody should have an agreement, at least on what the size of the pie is before you start. And then you can talk about, the issues, whether or not the joint account falls into the estate, but at least you know what the size of the joint account is. And you can talk about undue influence. You can talk about all these other things, but if you don't know what you're dealing with in terms of the size of the estate, you waste so much time. So if you're going to have a shortened mediation date, be prepared, counsel, and come to the table prepared to agree on at least what the size of the pie is, or the approximate size of the pie.
So you said your bias is against a hard stop. Have you ever gone to the middle of the night in a mediation, either as counsel or as mediator?
I have gone to early morning hours as counsel. As mediator, I don't think I've gone, later than, 10 o'clock at night. And I don't want to go, to the early morning hours. I'm getting too old to do that. And I just feel that it gets to a point where if people are too tired and they make a concession at midnight, what may happen is they're going to really regret it the next day and feel that they were pressured into doing it. I would much rather tell the parties, look, we've made some progress. Let's make note of where we're at right now. Let's make note of where we're you got a semi-agreement, and let's pick this up on another day when everyone's, feeling rested.
I think you make a really good point, because isn't an interrogation technique, to wear someone out? And finally, they're so tired, they'll admit anything, whether, admit a crime they didn't commit, or in your case, settle a case, okay, let my brother have everything or whatever, because it's 3 a.m. and I want to get to sleep. And I'm sure those kind of settlements, it's probably even possible to later claim that they're not valid because, people were too tired to make rational decisions. It's the kind of thing you see in the real estate market where, there's auctions and people are bidding and bidding and bidding and bidding, and they kind of lose their heads. So I think what you're describing makes a lot of sense. Anything else you want to add to what we've been discussing today? So there's kind of a few models. There's the hard stop at 5. There's the, maybe we'll go till 8 o'clock if we're really on a roll, or if not, we'll adjourn. Or there's the, look, we're staying at till 2 a.m. and I'm going to lock you in the room. Have you ever had that kind of thing where a mediator would say something like that?
Well, I actually do allude to it quite often in our opening sessions, where I say, look, I can't force you to stay here, even though it's a mandatory mediation. You're free to go, but my job is to keep you in the building or keep you in the room talking. I'm not like there was a judge in Ontario. I'm not going to mention names, but the judge is very well known. And she would basically lock counsel and their clients up in the courthouse, and they don't leave until they reach a deal, and was very successful. But I'm not a judge. I don't have that kind of power. I don't have superhuman powers or strength. And what I also wanted, and I've talked about this in another video about, how to reduce stress in mediations. I see my role as reducing stress, not adding stress to the parties. And I say to them, look, litigation, it's not only, the costs, it's the emotional stress costs. So my personal approach is I don't want to add to that stress by putting undue pressure on the parties.
That makes a lot of sense. Thank you very much. Our guest today has been Charles B. Ticker, estate mediator and litigator. Charles, thank you very much.
My pleasure.